We have with us today Jennifer Winking, an attorney specializing in employment law and workers' compensation, and she will be giving us a few pointers on the Americans with Disabilities Act. Jennifer, what is the purpose of the ADA?
The ADA was a clear and concise measure by the Congress in order to prevent discrimination in the workplace and also to provide for ability for people who are disabled to enjoy the accommodations in public places as well.
Okay. And must all small businesses comply with the ADA?
Actually, the ADA is applicable only to employers who have 15 or more employees, and that's measured based upon a 20-week period from the two consecutive years, the preceding year and the current year. And so they look at whether or not you've had 15 employees for 20 weeks over a period of 2 years. And if you fall within that meeting, then yes, you are an employee or that needs to comply with the ADA. But keep in mind that if it is a public accommodation issue, then the number of employees makes no difference. It falls within a different meaning of that act. And also keep in mind that the Illinois Human Rights Act provides for disability protections as well, and they only require having one employee in order for the Illinois Human Rights Act to apply.
Very interesting. So generally, any business can be affected.
Yes, maybe not by the ADA, but definitely by the Illinois Human Rights Act, which would also protect discrimination for disabilities.
Okay. And how does the ADA define disability?
A disability is a physical or mental impairment that substantially limits one or more major life activities. And so we look at whether or not there's an impairment, and then we look at the substantially limiting issue, and then whether it affects a major life activity.
Okay. And what is a major life activity as it's referred to in this Act?
In the Act, that becomes a very important aspect of whether or not someone is disabled. And based upon the amendments to the ADA, which were handed down in 2008, the major life activity has been broadened to its almost broadest extent possible. It really means just about anything that you can do. If you are limited in it because of a disability, then that will be a disability within the meaning of the Act.
Okay. And can an impairment that does not affect someone all of the time still be considered a disability?
Yes, you're referring to episodic or conditions that go into remission. Mm-hmm. For example, cancer. If a person has cancer and that cancer is in remission, that they are still a disabled person within the meaning of the ADA. Likewise, other conditions that are episodic, you might have something that ebbs and flows, like asthma, where the condition may not always be a problem, but it becomes a problem sometimes. If it is a problem when it is in its active state, then it is a disability under the ADA.
Okay. Another question that often comes up, does the ADA force employers to hire unqualified individuals with disabilities?
No. In fact, that's not the intent at all. The intent is for leveling the playing field, allowing disabled people the same opportunities that anyone else would have. But no, it does not require the particular word being the unqualified. It's only implicated if a person is qualified with a disability, and that means that they can perform the essential functions of the job with or without reasonable accommodations.
Thank you, Jennifer. This has been very interesting, and it points out the fact that any employer should learn more.
Absolutely. Prevention is a major aspect of what I do, and very important for employers, because once the litigation has started, it becomes a much more expensive proposition. And then to know what the rights are, what the responsibilities of the employer are, and the rights of the employees are beforehand.
Thank you.
Thank you.